Cast is now starting. All attendees are in listen-only mode.
Good afternoon. Thank you for joining us as we continue the 2022 NACOL webinar series, a place where we can bring you information on the practice of civilian oversight, innovations in the field, and important work being done in the arena of criminal justice. We are glad to be able to welcome today's presenters, who will be discussing Brady and Giglio and the legal standards for what prosecutors must disclose about officer histories under their rulings. We will also be looking at what role civilian oversight professionals can play in improving police disclosure procedures and ensuring that defendants get information to which they are entitled. Before I turn things over, I'd like to remind all of you that you have entered today's session in listen-only mode. During the webinar, you will have the ability to type in any questions you might have for our speakers today, and those questions will then be posed to them following their presentation. I would like to also remind you that today's meeting is being recorded and will be made available on the NACOL website at a later date. And now to our speakers. Mary Azadi is the Constitutional Policing Advisor for the Orange County Sheriff's Department in California. There, as a member of the Executive Command, she makes recommendations and advises on constitutional law, accountability, adherence to best practices, and policies and procedures. Prior to this role, she served over 11 years as a prosecutor with the San Bernardino County District Attorney's Office. Mary is a member of the International Association of Chiefs of Police Legal Officer Section, and in this role, she has served on working groups developing multiple model policies for police agencies. We are also joined today by Andrew Case, who is Senior Counsel at Latino Justice, where he litigates against police departments and corrections agencies. He recently worked on a report that obtained and analyzed 181 cases in which New York City's Civilian Complaint Review Board had determined that the New York City Police Department officers had made false official statements in interviews and found that the NYPD only disclosed the CCRB's findings with regard to 5 of these officers. He has worked on cases brought against the Texas Department of Criminal Justice, the Arizona Department of Corrections, and the New York Police Department. Previously, he served as the Director of Communications and Intergovernmental Relations at the CCRB. I now turn things over so that we can begin today's session, and I will start things off with you, Mary.
Thank you, Cami. In the current digital age of technology and automation, it's easy to lose sight of the intrinsically human aspects of the criminal justice system. The criminal justice process is intrinsically entrusted to people, and it relies on the integrity of all persons involved, be it the person who calls 911, the officers who arrive on scene, witnesses who identify suspects and provide testimony, the attorneys, and of course, judges and jurors. The old system that merely trusts that the adversarial process will reveal exculpatory information or matters informing the credibility of a witness has proven to be ineffective. My mission with our time together today is to energize you in your role by discussing the law in this area and how your specific law enforcement agency or oversight entity can help address this fallible human process and protect against widespread injustice. Brady versus Maryland is almost 60 years old, and it doesn't seem to matter where you are politically or professionally, be it the Marshall Project, the International Association of Chiefs of Police, members of the media, the U.S. Department of Justice, prosecutors, judges, law enforcement agencies. It seems everyone agrees that disclosures must occur. But the reality is that policies and procedures that are currently in place are simply not getting it done. Ensuring that law enforcement, the first half of the prosecution team, is complying with their ethical and due process requirements has been a distinct problem for the criminal justice system. In Brady versus Maryland, the Supreme Court held that due process requires prosecutors to disclose favorable evidence to defendants. Then in 1972, in Giglio, the Supreme Court extended Brady to include impeachment evidence and not just exculpatory evidence. Now, throughout this presentation, I will use the term Brady to cover exculpatory evidence and impeachment material. Sometimes when evidence is impeachment, it is referred to as Giglio material after the Supreme Court case that extended Brady. But for today's webinar, I will use the term Brady and exculpatory interchangeably. And I intentionally include within the definition of exculpatory any kind of information that would cast doubt on the guilt of a defendant, including impeachment material. Some examples of exculpatory material are information that would negate a defendant's guilt, information casting doubt on the admissibility of evidence, any criminal record or criminal case pending against any witness whom the prosecution anticipates calling, inconsistent statements made orally or in writing, and information that would diminish the degree of the defendant's culpability. Any proposed witness having a personal bias against a protected class, and of course, an official finding of misconduct that reflects on a witness's truthfulness, bias, or moral turpitude. This would include an officer's excessive use of force or records related to serious misconduct on an officer. In 1985, in US versus Bagley, the Brady Doctrine again expanded. The Supreme Court eliminated the requirement that the defendant make a request for evidence. Brady is a self-executing and affirmative obligation on the part of the prosecution, independent of any defense action. These principles have been reaffirmed countless times and continue to be expanded as they were heard. In Kyles versus Whitley, the individual prosecutor was held to have a duty to learn of any favorable evidence known to others acting on the part of the government, and this includes the police. Exculpatory evidence could not be kept out of the hands of the defense just because the prosecutor didn't have it, but the police agency did. Brady is violated when the government fails to turn over evidence known only to police investigators and not the prosecutor. The Brady decision itself even emphasized that failure to disclose Brady information violates due process, irrespective of the good faith or the bad faith of the prosecution. These incremental extensions invigorated Brady, and it extended their principles and essentially legally eliminated the ability for a prosecutor or a law enforcement agency to remain ignorant of Brady material. Police agencies and prosecutors are part of the same prosecution team, and for a Brady analysis, they are deemed to be one and the same. A Brady violation essentially has three elements. First, the evidence must be favorable to the defendant, either because it's exculpatory or impeaching. Second, the information was not provided to the defense, either because it was actively hidden or not explored. And the information must be material, where there's a reasonable probability of a different outcome as to guilt or punishment. Brady disclosures are required at all stages of the criminal trial process. This includes pretrial motions, such as search and seizure motions, evidentiary motions, such as a suspect statement under Miranda versus Arizona, or post-trial motions, sentencing, motions to reduce sentencing enhancements, or motions for a new trial. The duty to disclose continues during the trial and after conviction. These disclosure obligations are wholly independent of any statutory scheme of reciprocal discovery. These due process requirements are self-executing and need no statutory support to be effective. Now, Brady does have some limitations. The court in US versus Bagley limited Brady's reach by extending it only to material evidence, which it defined as evidence that is so favorable to the defense that there is a reasonable probability that had the evidence been disclosed, the result of the proceedings would have been different. Also, multiple circuit court of appeals have found that mere speculation that a government file may contain Brady material is not sufficient to warrant an in-camera review, much less a reversal or a motion for a new trial. You may wonder then, what qualifies as mere speculation? That an example would be a frivolous claim or something based on rumor or unverifiable hearsay. Then, more recently, in US versus Ruiz, the Supreme Court limited Brady's reach again when they held that a prosecutor need not disclose impeachment evidence prior to a guilty plea being entered. This does not mean that a reciprocal discovery statute isn't violated. It only states that this is not a due process requirement. As with any other federal constitutional issue, state constitutions, cases, statutes may not diminish federal constitutional requirements, but may increase them. These limitations are examples of some of the difficulty in establishing standardized Brady protocols. As a result, I urge you to please look at the research in your law and research the law in your area to determine what these limitations are in your respective jurisdiction. So, what should a law enforcement agency do? Law enforcement agencies should resolve doubt in favor of disclosure. Since police agencies and prosecutorial bodies are on the same team, I believe this quote should be edited to include and put the onus on all of the entities involved. So let's discuss the bottom line. Law enforcement investigative agencies have a due process affirmative duty to disclose to the defendant all material evidence that is favorable to the defendant and possessed by the prosecution team. Peace officer witnesses and Brady. The information involving Brady peace officer witnesses could be on-duty conduct, testifying dishonestly, being dishonest in an investigation, such as report writing or during an internal affairs investigation, and off-duty conduct. Brady information can be located in a variety of places, including criminal files submitted to the DA's office, courtroom testimony, search warrants, motions, inconsistencies in reports and other evidence, media reports or citizen reports, officers placed on conduct-based administrative leave, and, of course, sustained findings of misconduct involving moral turpitude, such as dishonesty or bias. As you work through your agency's Brady compliance or oversight of a law enforcement agency in this area, you might hear some common concerns from police officers. For officers, Brady's application to their personnel file is not about their lives, but it is about their livelihoods. If the misconduct calls into question the officer's credibility, that officer might not be trusted to testify again. In that case, an officer would have a Brady jacket and may find herself out of work and unemployable. For a Brady officer, there's an implication that the officer cannot make arrests, investigate cases, or carry out any other duties that would otherwise place them on the witness stand. In addition, officers fear that prosecutors and police supervisors will use access to the files to abuse the Brady designation by labeling an officer as Brady to punish them outside of the formal disciplinary channels and coinciding procedural protections. Scholars have said, and I agree, that Brady has become not only a matter of a defendant's due process trial rights, but also of a police officer's due process employment rights. States have differing protections for peace officer personnel records. In some jurisdictions, they do not exist. Some have limited public disclosure, while others require an in-camera review before anything can be shared. At the end of the day, presence in the Brady system in and of itself is not an automatic kiss of death. Now, the underlying conduct may very well warrant the removal of the police officer in their duties. But presence on the Brady list or the Brady disclosure in and of itself is not relevant to the employment consequence. It is the underlying conduct of the officer that should be disciplined. Courts ultimately may decide to even exclude the evidence that's disclosed when balancing its relevance and probative value. Also, the impact of impeachment evidence may not be as significant as initially imagined. Each case must be evaluated individually. We have to allow the legal process to play out. Police agencies cannot proactively restrict the possibility of the legal process to unfold by failing to disclose the information to begin with. One example of many for motivating factors for a police agency could be the potential liability for a subordinate's conduct. Supervisors may be liable for their subordinate's violation of other constitutional rights when they know about the conduct, facilitate it, approve it, condone it, or turn a blind eye for fear of what they might see. For a variety of reasons, including those that we've already discussed, a frank and emotionally intelligent conversation with police agency members will need to occur when establishing or reviewing Brady protocols. According to Chief Judge Alex Kaczynski of the Ninth Circuit, there is an epidemic of Brady violations abroad in the land. Only judges can put a stop to it. While I hesitate to disagree with him, I think law enforcement agencies and oversight entities need to be and should be a part of the solution. What can you do? Review and draft policies. Audit trainings. Create procedures to retain records. Have appropriate documentation and sound disclosure mechanisms. When it comes to policy, know the law in your jurisdiction. Not all cases are the same. Depending on the type of case, there may be additional Brady disclosure obligations. The policy provided here is a sample from the International Association of Chiefs of Police to help get this conversation going. It is the policy of this law enforcement agency to follow disclosure requirements consistent with the law, to include identifying and providing to the prosecution, upon their request if applicable, any exculpatory material that would have a reasonable probability of altering the results in a trial, any material that could reasonably mitigate the sentence of a defendant, and any material relevant to the credibility of government witnesses, including but not limited to law enforcement officers. To implement a disclosure policy, agencies must take steps to determine where relevant information may be located in an agency's record. Agencies should conduct an inventory of the various potential repositories of information. Disclosable information may find its way in non-traditional sources, which would be police reports, investigator notes, and personnel records. For example, exculpatory information could be located in computer records, mobile data terminals, recordings by body-worn or in-car cameras. The existence of such records, even including social media posts that might contain exculpatory information, may be discoverable as well. Training. Agencies should develop clear guidance regarding the impact of policy violations involving integrity, honesty, and credibility. This should include not only initial training, but ongoing training to all employees involved regarding exculpatory material, disclosure requirements, and their potential impact on employment. These are affirmative legal obligations with risks for supervisor liability. The training should also define terms. We've already discussed exculpatory evidence and material evidence, but two other important terms are the duty to inspect and the duty to disclose. Agencies should review any and all records related to potential exculpatory evidence, provide notice to the employee, and some form of internal protections for due process to protect the employee from harassment or an improper classification as a Brady officer. Also, agencies should provide the relevant prosecuting authority with potential exculpatory evidence, regardless of whether the prosecutor makes a request for such evidence. Procedures to consider. Consult with counsel regarding records retention to ensure that there is proper documentation between the police agency and the prosecutorial body. Agencies should receive written acknowledgement from the prosecutorial body and ensure that their documentation and investigative practices are up to date. Law enforcement agencies should balance the need to make disclosures in a timely manner while protecting an employment's due process rights, with a strong, significant emphasis on notifying the prosecutorial body responsible in a timely manner. Policing as a profession is necessary. Police officers are public servants in positions requiring significant public trust. When it comes to Brady disclosures, we can't leave the search for truth purely in the hands of the adversarial process. Law enforcement agencies and oversight entities should work together to be a part of the solution. And with that, I'd like to thank everyone for joining me so far. And I'd like to pass the presentation on to Andrew Case, who is a manifestation of how to work to be a part of the solution. Andrew? Andrew, I think you're on mute.
I am. I'm back. Do you guys? Great. So thank you so much, Mary. I am Andrew Case. I'm senior counsel at Latino Justice, and I want to talk a little bit more in detail as to the specifics of what kind of material a civilian oversight agency of any model is likely to find that can be Giglio material, and about an investigation that Latino Justice did specifically into the New York CCRB and the New York Police Department to see how the Brady Giglio disclosures were working. And one thing I want to follow up on what Mary said is that as Giglio is the framework for officer credibility, so it's impeachment material. So that's really what we are focusing on when we're talking about officer statements, officer conduct that would be relevant to a future case. Obviously, when you're a law enforcement agency, you have Brady material specific to a case about whether it's exculpatory to that defendant. But what we're talking about is material that is specifically about officer credibility, which puts it in the world of Giglio, though the same standards apply as Brady. Civilian oversight agencies are not part of the prosecution team. One of the things that you heard Mary say over and over again is the prosecution team, and the prosecution team involves the police. So I think we both agree that civilian oversight agencies do not themselves have an affirmative Brady obligation. But just about any Brady Giglio material that a civilian oversight agency sees is also going to be seen by the police department, and is certainly going to be in the knowledge of the individual officer involved. And courts have found that even if you're talking about testimony at a civilian oversight agency, the officer who's a member of the prosecution team knew that that testimony existed. So that testimony itself, that evidence itself, does become Giglio material, even if the civilian oversight agency is not itself responsible in a legal sense for providing it. That being said, civilian oversight agencies are in many circumstances best positioned to ensure that Brady Giglio violations don't happen by making disclosures themselves, either to district attorneys or to public defenders, and going through that process without relying on the standards in a police department to make those disclosures to the DA and ultimately to the defense counsel. And one of the things that we found is that there's systemic issues with how the police departments handle these complaints that may make it difficult for them to, or may make it unlikely that they will always comply with their Giglio obligations. So thinking again is what kind of things are Brady Giglio material that a civilian oversight agency would come into contact with? First of all, a denial of misconduct, even if the agency doesn't find the officer lied. A lot of times in a lot of agencies, and this is certainly true of the New York CCRB where I used to work, you have a very limited category of what's a false official statement by an officer. And you usually do not include an officer simply denying that the misconduct took place. And that's a perfectly legitimate policy decision. A lot of criminal law articles about denial and whether it's a perjury, all that kind of stuff is very robust. However, it is probative of whether or not the officer has a tendency to tell the truth, and therefore it is disclosable Giglio material, even if the officer doesn't get punished for it, and even if the agency doesn't say we're substantiating a false official statement here. More concretely, testimony that's contradicted by video evidence, testimony that's contradicted by documents is obviously going to be Giglio material. And as we said before, the agencies can speak to an officer's credibility and can provide this material to the DA or to the public defender, even if the police department does not. And that's what we're looking for now is a set of best practices for civilian agencies, regardless of their model, to make sure this information gets passed on. So one thing I want to point out is there's a quote on the left from a recent case, and it's a really interesting idea of how to frame civilian oversight Giglio material. This is a case in which the New York CCRB had substantiated allegations against an officer. The officer's interview had been a series of denials that he could remember the incident. I don't recall, I don't recall, I don't recall. I'm sure everyone who's watching is familiar with police officer statements that they don't recall something on various levels of credibility. Sometimes officers, in fact, are not expected to recall long ago incidents that were fairly routine. But if an incident was not routine, and if it was not long ago, and an officer says they don't recall it, oftentimes that's a question that will call their credibility into question. And in this case, an officer, the CCRB had substantiated the allegations, had not said that it found the officers were lying, but part of the analysis as to why it substantiated the allegations was that their statements were not credible, or at least they had made statements that they could not recall a recent incident. And here, when that case had not been disclosed, and the officer later testified in a criminal case, the court found that the failure to disclose that evidence was a Brady violation, a Brady violation through Giglio. So again, false official statements are just the tip of the iceberg for this material. It really has to do with anything that is probative of the character for untruthfulness. So I want to talk about what we did and what we found. A couple of years ago, the New York Assembly repealed what was called Civil Rights Law 50A, which was a very strict police records privacy law. It made almost all police disciplinary records completely not subject to FOIL, which is New York State's public information law. That law was repealed, which allowed for a much broader disclosure of police disciplinary records. And we sent a request to the CCRB specifically for cases in which it had found that an officer made a false official statement. Now, the New York CCRB has a specific protocol here. I suspect a lot of agencies have some kind of similar mechanism. It is not technically in the New York CCRB's jurisdiction to find that an officer made a false official statement. That changed actually in 2019. So one of the things that I want to put forward here is that the New York CCRB actually right now is a very good example because they have a lot of forward policies based on changes in the last couple of years. So even though the examples I give will show failings in New York, I do not mean to disparage the New York CCRB, which is taking a pretty aggressive stance on a lot of these issues. But because of the change in the law, we were able to obtain these cases. And over the course of 10 years, it was 181 cases in which the CCRB had made a finding of false official statement. Now, what they do, as I said about the jurisdictional issue, is they call this other misconduct noted, false official statement. They can't substantiate it, but it is noted in the case file. We were able to obtain the actual files for most of the cases and interview summaries for those where the actual file was not available. So we had a very robust response from the CCRB where we could look at what evidence was presented, what the officer's statement actually was, why this finding was made in a very detailed, specific sense. So we also looked at what the NYPD's disclosure policy was with regards to Brady material, because they had, in response to a lot of public advocacy around the Brady issue, they had created what is called the Adverse Credibility Committee. This was a group of NYPD officials who reviewed court cases, usually suppression hearings, and they looked to see if there was judicial language calling into question an officer's credibility. Usually, if a piece of evidence is suppressed, actually not usually, but often when a piece of evidence is suppressed, the court will say that they did it because they didn't quite believe the officer's story. And so the Adverse Credibility Committee, and you can see the picture in the top right of the screen, would have entries for when there was a court ruling that called into question an officer's credibility. This is actually a very straightforward and effective Brady-Giglio device and protocol for as far as it goes, because testimony in court is not the only place in which Brady-Giglio material can be found, but this shows a pretty effective protocol for that kind of material. Now, at the same time, the CCRB material was notably inadequate. And the reason for that is if you look on the below, as I said, the CCRB categorizes a false official statement as other misconduct noted. Now, it usually will say other misconduct noted false official statement when it sends that to the NYPD. But what we see here below is a letter from the District Attorney's Office of Brooklyn, and the Brooklyn District Attorney makes its Brady letters public, which is a really good step for them. The other misconduct noted doesn't say what the other misconduct was, and that comes from the PD this way. We reached out actually to the Brooklyn District Attorney's Office. They told us that this is the complete information that they get from the PD. So you have a situation where the CCRB investigates a case. They find that the officer made a false official statement, said something that was contradicted by video evidence or by their own memo book or something. And they forward that to the NYPD. And one part of our investigation that we're not talking about a lot today was the NYPD didn't actually discipline the officers in accordance with its own policies as robustly as it says it does. But the other aspect was how they play out in the Brady context. And here you can see with the OMN that all that was revealed to the DA and then through the DA to the public defender is that there was some other misconduct without a real robust statement as to what the context was. Now, I want to give a couple of examples of what we have found in these actual cases so that you can see what kind of things we're talking about. Because one of the things that I want to try to leave you with today is the idea that this does not have to be a lie about the most serious thing in the world. This does not have to be a false statement about the use of a gun or a act of horrific misconduct. So I want to start with Pio Leonardo in a very ordinary pedestrian stop. If you can see in the picture here, what happened was a woman's car gets pulled over. She asks the police officer for his name and badge number. The only piece of paper she has is her checkbook. So she pulls out her check, she turns over her check, and she asks the officer to write down his name. And he writes P-O-L scribble, 2-O scribble scribble, and a little line underneath it. And according to her at her CCRB statement, when she came in, she said, I then looked at his badge, saw his name was Leonardo, and wrote down Leonardo so that I could remember it. So she comes to the CCRB and she's filed whatever complaint. It doesn't really matter. And she claims that he didn't give his name and shield, and she obtained his name by writing this down. So in addition to whatever she's talking about with the discourtesy or so on, such forth, she also has a failure to provide name and shield allegation. When Pio Leonardo comes in, he says, yes, I scribbled my name and scribbled 2-O scribble something. But she asked me what my name was because she said she couldn't read the scribble, so I wrote my name out more carefully belowhand, and that handwriting down there is my handwriting. And so the investigator looked at the woman's initial complaint, which was handwritten, in which she wrote that little E and that little A that are sort of large, even though they're small. They looked at Pio Leonardo's memo book and saw that he writes his memo book almost exclusively in all caps, and concluded that this looked like her handwriting and not like his handwriting, and that he had not, in fact, written his name on the check. Completely trivial encounter, totally understand. It's not a hugely important act of police misconduct, except that what happened in the New York City Police Department's disciplinary system is Pio Leonardo was disciplined for failing to provide his name and shield number, which means the NYPD recognized that he did not write his name on the bottom of that, or they wouldn't have given him the 3 days of vacation that he lost for this. And yet it did not pursue anything for a false official statement, and it did not disclose a false official statement when later in later letters that we see from the DA. Someone would argue that this is a very trivial incident and therefore it's not that important. What we would say in response is this is a case where if the officer had gone in and told the truth and said, I scribbled my name, I thought she could read it, I guess she saw my badge and so she wrote down my name, it's hard to conceive that he would have been severely punished. He might have gotten instructions, he may have lost 1 or 2 vacation days, but that would not be seen as a terribly serious infraction. He went through the trouble of writing out his name, even if it's not particularly legible. And so what we have is somebody who was willing to tell an easily verifiable lie in order to avoid an absolutely trivial punishment. And put in those terms, you can understand why if somebody is then testifying at a suppression hearing, that they may be willing to say something untrue in order to get the result that they want, because they have said something untrue in a very, very low stakes context. And so recognizing that trivial lies are not trivial when you're talking about someone's tendency to lie when they're dealing with criminal justice issues is very important. Second example is exactly the kind of example that you would see incredibly relevant to a suppression hearing. This is a case in which Officer James Slavinsky and his partner watched someone enter a building, waited about 10 minutes, saw him exit the building, and according to the man, they then grabbed him and searched him. And in fact, according to the criminal complaint that they later filled out, they wrote that the narcotics that they recovered from the man, the glassy envelopes of heroin, were found in his pants pocket. And on the misdemeanor narcotics possession facts sheet that they filled out, Detective Slavinsky wrote that in answer to the question from where were the drugs recovered, he wrote defendant's pants pocket. So we have two pieces of written evidence from the detective prior to the CCRB interview that he recovered the drugs from the pants pocket. Sometime before he was interviewed by the CCRB, he learned or was told that you're not allowed to simply search someone's pockets when you see them coming out of a building after they spent 10 minutes inside, even if you suspect they went in there to buy drugs. And we all know what various levels of probable cause and reasonable suspicion are. And so what he said when he was interviewed by the CCRB is, quote, once he realized I was following him, he claimed that he just started following the guy without running after him. He dropped some narcotics to the ground. I recovered the narcotics, seen what it was. I called over my partner on the phone. So he says he saw I was a police officer. He threw the drugs to the ground and ran off, and we caught him. That would, of course, not involve any civilian misconduct. If he, in fact, did throw drugs to the ground, then you could pick up the drugs and field test them and then arrest the guy later. But it is contradicted by two statements that he submitted himself, one of which was a criminal court complaint, which is sworn. So the CCRB determined that he had done the stop improperly and that he had made a false official statement when he said the man threw the drugs to the ground. The NYPD, again, as you see in the disclosure below, they punished the officer for an improper stop and for an improper search, thereby recognizing that he did stop and search this man without probable cause. But they did not discipline him for the false statement. And when this was disclosed to the DA and later to defense attorneys, it was noted as other misconduct noted other misconduct. Now you can see why a defendant at a suppression hearing in which this officer claimed, for example, that he either had probable cause to search for some reason or that the man had thrown drugs to the ground and that's why he was able to search them, or any number of other things, that a statement directly contradicting your own sworn criminal court complaint about what somebody did and why you had the right to search them is incredibly relevant. And if somebody is in a criminal, under indictment and dealing with a suppression hearing and doesn't know that this happened, they're at a huge disadvantage when cross-examining this witness. So to put this into real precise framework for what agencies can do to identify and put forward this material, as Mary said, it's important to have a process. And an important part of that process is identifying how much material actually qualifies as this to begin with. So if you are in an auditor model, you can look at law enforcement investigations, you can look at IAB investigations and see, have they identified when an officer is, even if it's not a false official statement or a perjury or a lie or whatever you want to call it, if it's something that speaks to the officer's truthfulness, even if it's I don't recall, even if it's mildly contradictory in some way, then you can take that opportunity to identify to the law enforcement agency that these are being missed, and either with them or on your own develop and recommend a policy for them to be put in place. Police commissions can set the kind of policies that Mary set forth earlier from the organization that said that they are going to search for and identify this material. review agencies can look at individual investigations as they're going on and mention to the law enforcement agency or to the district attorney's office that they're seeing this material. And investigative agencies can provide this material directly to DAs. My understanding is that now when the CCRB finds a false, New York CCRB finds a false official statement, they will directly notify the district attorney's offices. I don't know that that extends to materials that do not rise to the level of false official statements, such as the I don't recalls or so on. But I think that that's an opportunity for investigative models to set up a, some kind of direct relationship with district attorney's offices to say how this material will get to them. So those are the types of material that we see falling in this category. Those are the types of things that we think agencies can do. And I'm going to close there so that we have time to have your questions.
Thank you so much, Mary and Andrew. And we do have a few questions here. Start by asking, has the New York City Civilian Complaint Review Board, as a result of the report that Latino Justice did, changed any of the policies that they are following?
So that's a really good point, because I think one of the things that happened is the change in the law that allowed us to get access to these documents happened after a change in the law, or just at the same time as a change in the law that allowed the CCRB to have its own jurisdiction over these. So now the CCRB is one of the agencies that New York CCRB can find false official statement in its actual findings, can bring that case to the administrative prosecution unit, which now administratively prosecutes CCRB cases. And so those cases are in a different posture now. They're not beholden to the NYPD. And I think they informed me in the course of this investigation that they already were notifying district attorney's offices. So I think the changes in policy actually were taking place at the CCRB. I'm not going to take any credit for them. They were actually going on in place before I started the report. The value of the report is both in terms of a possible future litigation about people that were harmed when the old policy was in place, but also in terms of spreading the information about what qualifies as Brady Giglio material, not just to the CCRB, but in forums like this. And so, one of the things that we'll follow up with the CCRB are about these lower level, not quite substantiated for false statement complaints, but they do speak to honesty, and whether there'll be some kind of traction there. But I think the CCRB has been pretty forward in this, and I wouldn't presume that I pushed them there because they were going there when I started writing the report.
Andrew, thanks for that, Andrew. And a quick follow-up question from one of our audience members. Do you know if the CCRB's policy regarding this is public? If others want to look at it?
I hope so, because I've been talking about it. I hope it's not a secret. All I have is a confirmation in a letter from John Darsh, and I'm sure that those of you in NACOL can reach out to them and find out exactly what their policy is. But I had a series of questions, and one of the questions was what was going on with these, and the answer was we forward them to the DA's offices. So to the extent that we know we have like a written policy, I would reach out to them.
Great. Thank you so much for that. And Mary, a question for you. How do you believe an oversight agency should consider an officer's testimony if they are on the Brady list already, when they are giving statements to the Civilian Oversight Office specifically?
How should the defense attorney consider it?
I think actually, how should the oversight entity handle statements given by police officers? That's how I'm reading it.
Well, it depends on their model. If they are an investigative model and they were previously somehow unaware of this potential false testimony, then they should open up an investigation and at a minimum alert the law enforcement agency, because oftentimes that happens solely within the district attorney's office. The district attorney's office then is now aware of this potential discrepancy and should independently pursue their own Brady investigative analysis. But as a precaution, not only should the oversight entity, the civilian review board or whomever, investigate themselves if their model allows for it, but also alert the agency. Because once you alert the agency, then they can no longer turn a blind eye to the information and have an affirmative duty to make that disclosure. So depending on their model, there should at the minimum be an alert, in my opinion, and also perhaps a notification to the district attorney's office.
Thank you, Mary. Our next question is, what are your best recommendations for oversight agencies who don't have law enforcement agencies that are cooperative with disclosure?
Do you want to go, Mary, or should I?
Go first.
So I would say bypass them to the best that you can. So if you, as the civilian oversight agency, have a relationship with the district attorney's office, there's nothing to stop you. And I don't know what the model is. I don't know what the. So if you have an investigative model, you can forward notices of your investigations to the DA's office. Whatever there might be some kind of restrictions in place, but they're not going to trump the 14th Amendment, which is what Brady operates under. So if you have a state disclosure law, federal constitutional law would there still would be a Brady violation if this is not disclosed. So I would try to reach out to your district attorney's office and say, how can we set up a pathway to exchange information that would be compliant with whatever laws and regs we have to work with? And then if you're generating the Giglio material in your interviews, then you can hand it over to the DAs. If you are a review or an auditor model, then again, if you see Brady material in police files and you notify the police department and they say, we disagree with you, that's not Brady material, you can either take that to the DA, you can, I would try to bypass the police department as best I can if they're not on the same page with Brady. If they're the ones you're bailing out, they're the ones that are going to get sued when someone like me comes along and finds 150 cases and digs through their files.
And to that end, I would also add that that's part of the reason I included those concerns, those common concerns from law enforcement officers, is I think there's a distinction between Brady and how their personnel matters and their disciplinary matters are being handled. And to the extent that the agency is perhaps being challenging in committing those proper disclosures, I think that they need to be educated. And there needs to be a training, not only to the line level, but also ongoing training with the command staff and the folks that would ultimately be responsible for the constitutional violations, to understand that they are responsible for their subordinates' conduct. And this is a constitutional violation. And this is not negotiable. And I would highlight some of the advocacy groups such as International Association of Chiefs of Police and other law enforcement agencies that insist that disclosure must occur and that you have a significant risk in supervisor liability if you don't disclose it, if that's not already enough to know that you potentially are having someone behind bars that doesn't belong there. I mean, that should be reason enough. However, in the event that they need more persuasion, I think that supervisory liability and also their ethical and due process obligations should help get them a little bit closer to center there.
And I think educating law enforcement of Brady doesn't just mean scaring the bejesus out of them, because one of the things about Brady is this is about whether the evidence can come in and be presented to a judge. It doesn't mean, as Mary said very eloquently to start off with, that everyone on the Brady list is forever tarnished. Everyone's going to have some kind of Brady disclosure if this is done robustly. And so, okay, 10 years ago, you didn't give somebody their name and shield number and you wrote in a piece of paper the wrong thing. Did you do that? Yes. Are you sorry about it? I mean, you can, just because it happens once doesn't mean that the officer's testimony is going to be completely thrown out. And you can tell the law enforcement agency better to try to clean up an officer's testimony after the fact about a prior incident than to violate the Constitution by not disclosing it.
Thank you for that. So we have several questions that center around this particular one. Is there any risk that investigatory materials from an oversight agency could be used against the defendant in a criminal matter if the materials turned over to the DA? If so, should informed consent be given to complainants?
I think that's a risk regardless of Brady. I think that that's something that every agency has to have a policy on. I know that we had policies on criminal disclosure and cooperation with DAs and all of that. So those are, I think whatever relationship you have with your DA in terms of investigations for the complainant side is not affected by this one way or the other. I think you've got to be careful of those issues, but you certainly, you know, I understand it's going to be a different defendant, right? It's going to be some person 5 years from now that the other officer is testifying against. But I mean, I just think those are case by case issues and agency by agency issues.
Thank you for that. Our next question is, what kind of training do you recommend for civilian review professionals or civilian oversight professionals to distinguish between officer statements providing knowing falsehoods and honestly believed but not correct statements by an officer owing to human factors? Mary, you want to take that one first?
I'll start that first. You know, I think that there's a variety of different forms of training that would assist. And I think that understanding the different levels and having just that broad, kind of like that broad scope that Andrew discussed, having 101 different cases, you start to see when certain things are incorrect versus dishonest. And at the end of the day, it is a judgment call. Right? Was this person incorrect in what they said, or were they being dishonest? It's incorrect. It's not incorrect to say that the drugs were recovered in the person's pants pocket versus they're on the floor, right? That's a credibility issue. That's not a right pocket versus left pocket. Perhaps I made a mistake between my left or right side. So it's difficult to have a training for some of that. I think some of it is just exposure and having access and perhaps real life examples. And now as public personnel files are becoming more and more available to the public, like the statute that Andrew mentioned, I know in California under SB 1421 and SB 16, Penal Code 832.7 has been edited to allow for public disclosure of many officer personnel files involving misconduct. An oversight entity could pull some of those and look and see how they've been adjudicated administratively and whether or not they are being properly classified as a error versus a credibility issue.
Great, thank you. I think we have time for a few more questions. So the next one is, to meet the requirements of Brady Giglio, different bodies of government may be required to cooperate. For instance, a municipal government, the police, will have to work with a county government, the prosecutor, and vice versa to ensure the requirements are being met. How does an oversight agency for the police that has no authority over a county prosecutor ensure that Brady requirements are met? Andrew, you want to jump in on that one?
Sure. So that's a really interesting question, because that comes to the issue of, if you're providing it to the DA, what are they doing about it? And what are they doing that's not, that is or isn't proper? And so I'm working in jurisdictions in New York City where the prosecutors have all kind of gotten on board with the idea that they have robust Brady Giglio obligations, and they have these protocols where they, every time someone's going to testify, they send out a letter, and there's a lot of stuff in the letter that's someone might say is overly robust in disclosure, but it's, you know, better than too little. And so I think that the process of education of a prosecutor's office is really important, and you can bring in your public defender's office with that too, and try to have like a roundtable with your agency, the public defender, and the prosecutor, and you could start saying to the, I don't know what your, this becomes the confidentiality issue, but I would say in some instances you can go directly to the public defenders, but don't do that on my advice without knowing whether that's a disclosure issue in your jurisdiction. But certainly the issue can be brought up to both the prosecutors and the defenders will make it very clear to the prosecutors what they think the Brady obligations are.
Okay, thank you. And so the next one, I'm not sure if either one of you will have an answer to this, but there are multiple people who have made, have typed out similar questions. Do the panelists have any suggestions for where to start if both the police and the prosecutors are resistant to disclosure and are not afraid of Brady litigation?
bring the lawsuit.
Um,
If they're not
yeah,
concerned
tell me
about
what your
mitigation,
jurisdiction is, man.
then I don't see why you wouldn't bring the lawsuit. I don't know, Andrew, you're the one that prosecutes.
Look. Obviously, a civilian oversight agency cannot bring a lawsuit, right?
Mhm.
But I mean, you can't. I don't know that. I mean, depending, you're under the same jurisdiction, whatever. But you can publicize this, right? If you say, if you are providing information to a police department or to a prosecutor or to both that you believe is Brady information, the people that will have the biggest response to this are the public defenders, because they will bring the lawsuit. I mean, depending on your jurisdiction, we have a very huge, robust public defending organization in New York that sues the PD all the time. But some local activists, we kind of operate nationally, so give me a call. But the only way to do that is to sue them. If they are resistant, then they're not afraid of being sued. Then someone has to sue them. I don't think that it would be you, but you'd have to make it public enough that the advocates that would bring a lawsuit can do so.
And I obviously.
Sorry.
Right, and I was somewhat tongue in cheek when I was saying, we'll bring the lawsuit, right? And the reality is that my preference is to work alongside one another, because I find that you get the most cooperation and you end up actually achieving more than you would sometimes as a result of that. But there are some places that are just so actively resistant that it requires some form of judicial interference. And so in that circumstance, if you truly don't have the choice, if you've made every ethical attempt, you have to act, because at the end of the day, there are potential cases that are being prosecuted and people's lives who are being impacted. And it's a fallible human process, but we have to trust the human process in the criminal justice system. And if you have that information and you have made every effort in order to obtain compliance, then either media or any particular advocacy group, especially I imagine you would have done sufficient research to provide that information, it would be a gift to them to bring forward to obtain that compliance.
Thank you, both of you, for that answer. So let's see if we can get a couple more in before the end of our hour. Do you think that disclosure issues are more the case of deliberate actions to withhold information, or is it more to do with a lack of knowledge, understanding, ignorance, and that it really gets down to training in many instances?
You want to go, Mary?
I truly believe that a lot of it is unfamiliarity, lack of information, fear of not knowing what exactly the implications are. But at the end of the day, the why doesn't matter. Brady made it perfectly clear that the good faith or the bad faith of the members of the prosecution team is irrelevant. Although the why may be helpful in trying to remedy some of the situations that are innocent, then that's an easy fix with training and policy and having compliance. Where it is malicious is definitely more of a challenge, and one can't predict to what extent it is. But with how widespread the lack of disclosure is, I would have to believe that a big part of it is unfamiliarity, laziness, or fear of what the Brady jacket basically provides for an officer. And so addressing that, at least from a baseline foundation, and then moving on to perhaps some bad actors is probably a fair strategy to take as far as civilian law enforcement oversight is concerned, because you're still helping move the ball forward. At the end of the day, it doesn't matter whether someone has good intentions or is just sloppy. It matters that the disclosure isn't made, and that's where the constitutional violation occurs.
Thank you. And with that, I actually think that we will have to conclude today. But on behalf of NACOL and the oversight community, I want to thank both of you, not only for being here today, but your willingness to share your experience and your knowledge with our community. This is how we do better work. So thank you so much for being here. And for our audience, I just want to let you know that we have 2 more webinars coming up this summer. We hope you will join us on July 11th when we will be joined by Dr. David Macon of Washington State University to discuss analyzing body-worn camera video. And then also on August 16th when we will welcome Tracy Mears and Jorge Camacho from Yale's Justice Collaboratory to discuss their work to define state and local authority as it relates to the goals of police reform. Registration for these events will be opening shortly, so please check your inboxes for information for when that happens. Thank you again, everyone, and we look forward to seeing you at our next event. Thank you.
Thank you.